Welcome to Your Inheritance, your rights, your obligations, your responsibilities, with your host, Peter Bochnewich. In each episode, you'll learn insights from experts. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Your Inheritance, Peter Bochnewich.
Good morning and welcome to the podcast. Today we're going to be talking about asset protection, rules of the road, and some thoughts on sophisticated estate planning in a changing economy. And our guest for our discussion today, so pleased to have him, gentleman has scores of published works on all of these topics, is Mr. Bruce Givner. Mr. Givner is an attorney who has been practicing law in the greater Los Angeles area for over 4 decades, concentrating on income tax planning, estate tax planning, sophisticated retirement plans, asset protection planning, charitable planning, capital gains planning, tax litigation, and the representation of high net worth and high income families, as well as individuals and their closely held corporations. Mr. Givner received his an LLM in tax from New York University School of Law, and was a graduate with his Juris Doctorate degree from Columbia School of Law and an undergraduate from the University of California, Los Angeles. Now, the podcast people need me to tell you this, and so I will say it. Nothing in this podcast is intended to provide legal advice to anyone. If you need legal advice, please seek out counsel, your own counsel. And jumping right into it, Bruce, thanks for being here. And I'd just like to jump into it and say, what is meant by the term asset protection?
So when you hear asset protection planning, Peter, a synonym is creditor protection planning. And most people think that we can do something that will absolutely make their valuable assets bulletproof, protected from some future plaintiff who becomes a judgment creditor. And there is very little that is bulletproof asset protection planning. What I like to explain to clients is it is like the Olympic competition where there's where people are running around the track and there are hurdles every 100 meters. So it's like putting a hurdle between your valuable assets and some future plaintiff who wins and becomes a judgment creditor. And the more hurdles you put, and most importantly, the single most important element far and away, timing. The older and colder that hurdle is, the better off you're going to be. So asset protection planning, the idea is to protect your assets from some future person that you don't like, and making you sleep better at night. Hopefully, if we're doing a good job, we pick the clients who do not have a problem today. We're picking someone who's smart enough to come to us, listen to this timing, more than 4 years before they have a problem. Unfortunately, about at least 50% of the calls that I get in a month about asset protection planning are really too late. They're already in a trial that they're going to lose or are afraid they're going to lose, or they've already lost, and I really can't help them. That's not asset protection planning. That, if I help them, would make me a party to a crime, because if they already have a judgment or the judgment's about to come down against them and they then do what they are told is asset protection planning, you can't do that.
Well, your answer is inspiring a lot of questions for me, and the 4 years is interesting, and I know we've I've looked into this before, but I guess the 4 years is to avoid any limitations period, any clawback periods. So when you say you've got to be clean of problems for 4 years, are you saying you can't have a lawsuit pending against you? You certainly can't be in a lawsuit. You can't have a lawsuit pending against you or even threatened against you. What's the cleanliness of the 4 year period in the run up? How would you describe that?
So prior to about 6 years ago, the law in California was referred to as the Uniform Fraudulent Transfers Act. About 6 years ago, it was replaced with what is now called the Uniform Voidable Transactions Act. The law is still in the same place, which is Civil Code Section 3439.01. However, it now goes to point 15. The statute of limitations is in 30, anybody can look it up, Civil Code Section 3439.09. And the basic statute of limitations is more than, you want to set it up more than 4 years, not before you get sued, but before the problem occurs for which you later get sued. So when I get called and they say, well, how long ago should I have done this? The answer is usually 5 years ago, because the suit that they just got served with relates to a problem that occurred a year ago. And it's actually worse than what we're discussing. If you guarantee a bank loan, let's assume you guarantee the bank loan in 2020 and everything goes wonderfully in 2020, 21, 22, and in 2023, something goes wrong and you can't make the payments. And now you do your creditor protection planning, you're really, really late, because the time to do the creditor protection planning was in 2019, before you signed the bank loan. And no one understands that. And the same thing is true with a lease. If you signed the lease in 2020 and you can't make the payments in 2023, it's not 4 years from 2023, it's 4 years from 2019 before you signed the bank lease.
Let me ask, if I may interject with a question.
Yes.
If you've got that long of a period, so it can't be at the time you sign the lease, or it's got to be before the lease. If they were able to prove facts that you were contemplating going into that transaction, does it reach back into that time frame even, or is that a case-by-case basis?
If you beat the 4 year statute, then you've beat the 4 year statute, and the judgment creditor can't say, aha, you did that to hint. By the way, the word fraud is still in the statute, even though part of the reason for changing from the Uniform Fraudulent Transfer Act to the Uniform Voidable Transaction Act was designed to get rid of the word fraud, but it's still in the statute. So if you did it more than 4 years before the problem arose, the creditor can't say, aha, you did that to hinder, delay, or defraud me. The judge isn't going to hear it, and your transfer will be protected. In other words, in my hypothetical 2019, let's say that you made a transfer to a children's trust. Well, if the problem occurs in 2023, and then the judgment against you is in 2025, the creditor can't complain about the thing you did in 2019. Doesn't matter what you did.
And does that, there are various forms of asset protection. I mean, it's a broad concept. Just to bring it down to basics, a lot of people might think that a standard trust that they do with their estate planning attorneys is going to give them some type of asset protection. And I suppose in the broadest sense of the word, you're protecting your assets by making sure the assets go where you want them to go. But in terms of protection of your assets from creditors, the state of California, in a inter-vivos revocable trust, there's how much protection? There's no protection, correct?
So a family trust, also called a revocable trust, an inter-vivos trust, a living trust, has absolutely nothing to do with creditor protection planning. It is a will substitute. It just provides who gets what and how they get it when you're gone. It has nothing to do with your ownership while you're alive. If all you do is transfer your assets to your own family / living / inter vivos / revocable trust, you own it for all purposes,
Exactly.
except probate avoidance. Now, if it's a husband and wife family trust and you die first and your half of the community property and your separate property goes into irrevocable trusts for the benefit of your spouse, okay, those irrevocable trusts, if they are created long enough in advance, will protect the surviving spouse from all but super creditors. We haven't talked about super creditors yet, but yes, to that extent, a living trust can be helpful, but you could accomplish the same thing with a will. So a living trust really has nothing to do with creditor protection planning. The kinds of trusts that have to do with creditor protection planning are irrevocable trusts, whether they are created in California, in one of the 16 states that have domestic asset protection trusts, or if you go outside the United States, whether it's to the Cook Islands, various countries in the Caribbean, or to Jersey, Guernsey, and the Isle of Man, which are very popular locations along with Gibraltar. So I hope I'm responding well to your question about a living trust.
You are. It's just it's a common misunderstanding, I think, from people walking in the door that we have to explain. I mean, I mostly do trust and estate litigation, some estate planning, not asset protection like you do really at all. But because of you really have to have the knowledge of where to do it and what states to do it in. We're going to talk about that. But people believe, oh, I've got my assets in a trust, I'm okay. No, you're not. You're not okay. If that's what your goal is. If your goal is to distribute your assets the way you want them to be distributed through a trustee and avoid probate, yes, you're fine. And that's what we can do for you. But we're not going to protect your assets from the judgment that you're about to get from the lawsuit that was filed 2 years ago.
Let me interrupt you for a second, Peter, and say that I'm a tax lawyer. In our firm, we have 6 other tax lawyers. So the question would be is, why the heck are you as a tax lawyer involved in asset protection planning? And the answer is that asset protection planning rests on 3 legs. One leg is estate tax planning, and that's about 25% of our practice, not estate planning. Estate planning is wills and trusts. We do some of that, but that's not the biggest driver of our practice. Estate tax planning is not who gets what and how do they get it when you're gone. Estate tax planning is how do you take 100 million and make it 5 million? So estate tax planning, because it reduces the value of the assets for estate tax purposes, those same structures, family limited partnerships, grats, skins, all those things also reduce the availability of the asset to some future, have to emphasize future, creditor. So that's one of the 3 legs of asset protection planning. The second leg of asset protection planning are retirement plans, both under federal law, ERISA, the Employee Retirement Income Security Act of 1974, and under state law, this is Code of Civil Procedure section 704.115. Retirement plans are extremely protected from all creditors except the 3 super creditors. I may as well say who they are: the United States government and spousal and child support. So again, 3 legs for asset protection planning. One is estate tax planning. Number 2 is retirement plans, tax driven mostly. And the third is irrevocable trusts, which are not tax motivated, whether it's done in Nevada or one of the other 15 states that have favorable asset protection planning laws, or one of the countries that I mentioned earlier. So that's why I, as a tax lawyer, am an expert in asset protection planning.
Great. You mentioned super creditors. So the United States government, if you owe taxes, there's no place, obviously, I mean, if you're justly owed taxes, is that what you were saying? The IRS is going to be able to go in any state. There's not one. None of the 16 states is going to prevent you from shielding your income from income tax. Excuse me, your assets from income taxes that you owe.
Yeah, don't say income. That's a different topic.
Yeah.
But yes, I mean, if you put assets in, let's say that South Dakota has the best domestic asset protection trust law. So if you put your assets in a South Dakota asset protection trust, the IRS in particular is not limited by that trust. Under Internal Revenue Code section 6324, they don't care. Now, whether child and spousal support can get to liquid assets transferred to another state's asset protection trust, that's not as clear. Certainly in a California irrevocable trust, child support and spousal support can invade a California irrevocable trust. But when it comes to the assets of an asset protection trust in another state, there was a very big case in June of 2019 called, In Re, which for the listeners stands for in the matter of. It's In Re Cleopatra Cameron Gift Trust. In that case, the South Dakota Supreme Court refused to give full faith and credit to a Santa Barbara family law court decision for child and spousal support against the Cleopatra Cameron Gift Trust, which her father set up for her. So I'd say that most people were surprised by that decision, but so far it or another case similar to it has not yet been appealed to the U.S. Supreme Court. So I think it's surprising that Article 4, Section 1 of the U.S. Constitution did not mandate South Dakota to enforce the California Family Law Court decision. And maybe someday that'll be overturned on appeal. But right now, we are setting up trust. Now, if you have the South Dakota Trust own an apartment building in downtown Los Angeles, I don't think that's going to turn out the same way, because a judge sitting in downtown LA doesn't care if the apartment building in LA is in a South Dakota trust. The judge is just going to say, I order the assessor to change title to that guy over there who's got the judgment. But liquid assets is a different story, because the judge can't order a non-California bank account to be changed to someone who's got a California judgment.
All right, so that brings up a good point. You said liquid assets, and that's under the South Dakota's decision is a fairly aggressive ruling, I guess, or you could say.
Well, I think so.
For the protection of assets in the housed liquid cash assets housed in the state of South Dakota in the trust,
or just not in California. We know the trust was in South Dakota. Where the trustee had the assets, we don't know, but it was certainly not something the judge in California could touch.
And the because of the strength of the trust and the policies of the state of South Dakota, they do not feel that they are subject to granting full faith and fair credit to the sister state judgment of California to apply that in their state, where they would almost do that in every other circumstance. But in this, because of the careful planning and setting it up to preserve the assets for a particular purpose, it's impregnable against that particular family law judgment. Is that a fair statement?
That's what they decided. Now, the Cleopatra Cameron case was not an asset protection trust. It was a trust set up by her father. Okay. However, it's very easy to see that they would decide the same way had Cleopatra set up the trust for herself. And it's also easy to see that Nevada would rule the same way. So it's a very influential decision, and one that I think is very suspect given Article 4, Section 1 of the U.S. Constitution.
which your states are supposed to respect the judgments of other states.
Yes, what the South Dakota Supreme Court said is, well, we don't have to enforce the judgment. You go, what? What does that mean?
Right. I have a question for you. Your very thorough response has given me a couple of questions. You earlier mentioned 3 super creditors, which seem completely logical. One which was apparently thwarted in this one family law situation in South Dakota, but
Oh, that was 2 of the 3. That was both child and spousal support orders.
Child support, spousal support, and
That's
of course
2 of the 3.
taxes. Now, what about if someone has a tax liability to the franchise tax board in the state of California? Are they a super creditor?
California is not a super creditor.
Okay, just the federal government and
Yes.
child support.
For example, if you have a retirement plan and you owe money to the state of California, the state of California cannot invade your retirement plan. Federal government can, the IRS can, but not the state of California.
Next question, because that's an asset protection vehicle, even if it's not an asset protection trust. You're talking about an ERISA-based plan like a 401k or a retirement plan. Is there greater protection?
By the way, Peter, just so you know, people think that in California their retirement plans are protected by ERISA. That's not the case. Their plans are protected by Code of Civil Procedure Section 704.115. California's protection for retirement plans is broader than ERISA, much broader than ERISA. So we're actually better off living in California when it comes to retirement plans than you are in practically every other state.
Good to know. So in California, there's rules against California being able to collect taxes from California retirement plans.
I wouldn't look at it that way. I would simply say that it's not the federal government has its own rules which preempt state law creditor protection.
Okay. Now, is there greater protection as between different kinds of retirement plans? Is there less protection?
Yes. Very thoughtful comment. Yes. So if there is an employer-sponsored retirement plan, which, by the way, it could be your own corporation, your own law corporation, and you're the employee/participant, that kind of plan is absolutely protected under California law. Okay, 704.115 little b. Okay, if you then terminate that plan and roll it to an IRA, the IRA continues to be 100% protected. That's due to what is called the tracing rule. So even though it's no longer a retirement plan, it's now an IRA. It continues to be 100% protected because it traces to an originally 100% protected plan. However, if you set up an IRA to which you contribute, in other words, a regular contributory IRA, that is not 100% protected. Under 704.115 little e, IRA, contributory IRAs, are only protected to the extent that the judge believes that you need that money for your retirement and for the benefit of the people who rely on you for support. So let's say there's $1 million in a contributory IRA, which means you had great gains. Okay, the judge could say, yeah, he only needs $400,000. You go, what?
How do they make that determination? Do they go based
The judge makes up his or her own mind.
Okay, so it's not based upon, look, I put this money in a contributory IRA based upon what I was earning and what I expected to pull out of it, and that'll
be your argument. That'll be your argument.
Right.
And the other side will say, nah, he's got a lot of equity in his house. He's got an apartment building. I mean, it's just an argument, and the judge will make a decision.
So when we say asset protection trust, I know that term has come out generally in our discussion here today. domestic asset protection trust or asset protection trust? What are we really talking about when we say that?
Excellent question. So our law comes from medieval England. I mean, this rule has its antecedents in pre-Roman law. But in any event, the direct rule is what is called a self-settled spendthrift trust. Self-settled means I create it myself. Spendthrift, it's protected from creditors. I'm a beneficiary, it's got my own assets. Well, it's against public policy that we inherited from medieval England for me to be able to take my own assets, put them in an irrevocable trust. I'm the beneficiary and it's protected from my creditors. Can't do that. Okay, that's the law we inherited from medieval England. Now in the 50s, the islands between France, not all technically between, but any of it, Jersey, Guernsey, and the Isle of Man repealed that rule. Now they are crown possessions, meaning they're not technically separate countries. So they're covered by the UK defense umbrella, but they're not covered technically by Parliament. And they repealed those rules. So people from all over the world went to those jurisdictions and set up self-settled spendthrift trusts. Then in the 60s, various islands in the Caribbean, and in 1985, the Cook Islands, which law was rewritten in 1989, allowed self-settled spendthrift trusts. In 1989, Alaska became the first U.S. state to repeal the rule against self-settled spendthrift trusts because Alaska wanted to get in on that trust business that was going to the Caribbean and to the Cook Islands and to the islands off the coast of France.
So with those trusts in those places, Isle of Guernsey, the Cook Islands, obviously, would those be called a foreign asset protection trust, or is?
Yes.
Because you're protecting your assets by using the laws of the
Yep. Those jurisdictions would not enforce another country's judgment against you as to the trust that you set up with your own assets to benefit yourself. Now, Alaska is a very unimportant state. So just a few months after Alaska repealed that rule in 1989, Delaware, the most important state in the country, and Nevada, the most important state to California, also repealed the rule against self-settled spendthrift trusts. And in the, what is this now, 34 years, if my math is any good, since another 13 states have also repealed that rule. So now, not all the rules are the same, and one can argue that South Dakota has the best law, or Nevada has the best law. Some people could argue that Delaware has the best law, but we only use South Dakota and Nevada.
Now,
go ahead, I'm sorry.
Let's say a judge, you've got the assets in an asset protection trust, liquid assets in an asset protection trust in one of these 16 states, I think you said it was, that have varying degrees of liquid asset protection. You touched on the fact that, look, if you've got real property and it's sitting in downtown LA and the downtown LA judge says that's not going to be protected, no matter whether it's titled to the trust or not, because the property's there in the state of California. So he's probably going to be able to reach that.
By the way, lawyers set those up all the time. I've seen lots of Nevada asset protection trusts owning real estate in California. And I go, that's a brain dead structure.
Well, so what can you do if it just can't be for real property in the state of California is basically what you're saying, because they'll be able to pierce it.
I don't think so.
or does it provide a hurdle even? I don't know. It's
so
not
in the asset protection planning basically started as a separate discipline in the mid 1980s. The godfather of asset protection planning, who passed away about a decade ago, Barry Engel of Colorado, started with a structure which we use very much to this day for estate tax planning and asset protection planning in California, a family limited partnership. But what he did was, instead of it being the parents as the majority limited partner, what Barry would do is he would set up a Cook Islands trust as the parents' living trust. And he did it on this basis. He said, if there becomes a problem, what you'll do is you will have the partnership sell all the assets, and then the cash for the parents' interest will go to the Cook Islands. Well, that's perfectly acceptable and logical, except none of our clients will do that. They're not going to sell all the real estate that they own in Santa Monica. But that was Barry's original structure, and he did thousands of them. Okay. So it is logical if you're prepared to sell all the real estate in California if a problem arises. But in fact, no one's willing to do that.
So as long as you're able to liquidate and create the liquid funds in that trust, then it's a viable protection vehicle.
And
if
it's
you have the wherewithal and the desire and the inclination to do that. But does it if you've run into a trouble, does it prevent the sale of the property to fund that trust because of the rules that you talked about before? At the beginning, we were talking about a 4-year period of having to be, look, you can't have any problems. This is not a vehicle where you can run away from something that you did wrong and park it in a trust and hide it that's not what it is. You've got to plan for the future and it's a legitimate vehicle. And there are certain states that allow it, but they have rules. I'm sure they have a checklist of rules arduous rules that you go through to make sure that you're clean of all of the things that before you can even establish it there, that you don't have any judgments pending, that you don't have a lawsuit against you. But if you find yourself where I've set this thing up in another state 10 years ago, completely clean, now I've got a problem. And the trust has some connection to real property, and I'm now selling that real property within that time frame. Does that affect the viability of the trust?
So there's sort of two types of responses to that. Number one, his idea was that if anything goes wrong, you immediately sell. So it might be that the problem occurred, but the lawsuit hadn't started. So it is very much a timing question, because you wouldn't want it to be that you were in the middle of the lawsuit and then you sold, right? Because potentially, I'm not a litigator, but potentially could the plaintiff get a court to prevent the sale while it's in the midst of a lawsuit? I think the answer generally is no. They have difficulty preventing the sale. But the other part of it is that the statute of limitations in the Cook Islands and basically every asset protection jurisdiction is 2 years. And once you've moved it there, it's even more complicated than that. But once you've moved it there, it's going to be, the 2 years is going to happen much more quickly than they're going to be able to get the judgment against you, because in California, it's typically 3 to 4 years to get the judgment. And one more point. If you do it Barry's way, which is you set up the Cook Islands Trust at the beginning, the 2 years is already over by the time you get sued. And also it's even better than that. The Cook Islands law tax the holding period of any trust to the 2-year period in the Cook Islands. So if you set up any trust in California and then transfer it to the Cook Islands Trust, the 2-year period is already run. So you're not going to get any leeway in the Cook Islands for sure.
Okay. A question for you. If a court decided that someone owed money and it came out that, well, you've got these liquid assets in the South Dakota Asset Protection Trust or an Alaska Asset Protection Trust or Cook Islands, and they said, we can't get at that money. And the judge could say, well, I want you to pay it, and therefore I'm going to make some orders that will be very uncomfortable for you if you don't pay it. Could a judge say, pay this money, I hold you in contempt if you don't pay it, and then you wind up paying it anyway.
Absolutely excellent. So what you're referring to is what is typically called the impossibility defense. Hey, I'd love to follow the court order, but I don't control the trust. And the judge effectively says, bull crap. And he says, I order you to bring that within this court within 120 days. And of course, they don't do it. So the judge then has a civil contempt order. And the civil contempt order is the judge can throw you in jail until the judge is convinced, and this phrase is difficult to understand, till the judge is convinced that you like your money more than your freedom. I say that really carefully. He's convinced that you like your money more than your freedom. So your lawyer says, okay, he's been in jail for a year. You got to let him out because he's never going to comply with your order. And the judge said, I think another year he might comply. Come back after 2 years. He's been in jail for 2 years. He's not going to comply. The judge says, I think another year he might comply. One of the longest cases on record of which we're aware is the judge kept the guy, this was a securities fraud case, federal, kept him in jail for 7 years before he let him out. The guy never complied. But civil contempt is almost all the cases of which I'm aware involve the federal government getting a judgment against someone. I am not aware, although it must have happened, that in a case in which the federal government was not the creditor, someone must have been able to convince a judge for a civil contempt order. But I was looking at it very carefully about a year and a half ago in connection with a California family law case, and none of the family law attorneys we spoke to have ever heard of civil contempt. Our client left the country conveniently with $35 million. We decided not to participate in the divorce. And so we were wondering, if he came back to the U.S., could a judge issue a civil contempt order? And everybody said, we never heard of it. Am I responsive to your question?
Yeah, you are. So civil contempt orders are severe, but we must be very circumspect for a court to go ahead and apply them. And there's a standard that they have to reach, but they're not a sword against asset protection trusts. They're not going to unlock the asset protection trusts in most cases. I mean, you described a severe example where someone, either waited it out or just couldn't do anything about it for 7 years, and that raises a lot of questions about the, his motivation and maybe the propriety of putting him in jail for 7 years over it. But that did happen. But a court can't just throw people in jail to circumvent the asset protection trusts of other states, basically.
So, other states, no, I'm not aware of that happening. Every case that I'm aware of involved in an offshore asset protection trust.
Okay, offshore.
By the way, it's not like you walk into court one day and the judge says, go to jail under civil contempt. It doesn't happen that way. The federal government, as the judgment creditor, asks for it, and it goes back and forth. And the cases that I've read, it took over 2 years from the time they started to ask for civil contempt to the court actually issuing the order. It went on for a very long time. So it's not like it just happens out of the clear blue. You see it coming like a freight train from 5 miles away. So it's a very unusual order, and it's not something that's sudden by any means.
Right. In common perception, the notion, even having a discussion about asset protection trusts in foreign jurisdictions, might greet people, well, that just is, there's something wrong with that. You're hiding your money offshore. That's a bad thing to do. But now you've got 16 states that basically allow for the same thing, or the protections is Alaska or South Dakota as good of a protection as, say, the Cook Islands?
So I think it's fair to say that if you've got $1 million or more and you want the very best asset protection trust, you're not going to put it in South Dakota or Nevada. You're going to go to Gibraltar or St. Kitts and Nevis or some offshore jurisdiction. No one, I think, has ever been able to get a penny out of an offshore asset protection trust. No one, including the federal government. The most famous case was the 1999 case of FTC versus Affordable Media, which also goes by the name of In Ray Anderson. The Andersons were accused of doing basically a Ponzi scheme, and the FTC got a judgment against them. The Andersons resigned as trustees of the Cook Islands Trust during the trial, which is a very bad idea. And of course, there was a judgment against them, and the judge threw him in jail for civil contempt because the FTC, again, that's the federal government, asked for it. Yep, super creditor, without a doubt. And the Andersons, after about 6 months, said, not a problem. We agree. We're going to go with you to the Cook Islands, and we're going to get the money out. So they went, the Andersons flew to beautiful, scenic Rarotonga, the capital of the Cook Islands, and they went to court, and they said to the trustee, Asia City Trust, which we use very commonly today, they said, please give the FTC the money. And Asia City said, no. There was no money. The FTC got absolutely nothing.
Now, was there resignation? And then
very bad.
Well, it took over as a success. Is if they were remain the trustees?
Oh, they could have done anything. Sure,
they could have done anything. And so, but
they our clients are never trustees of their offshore asset protection trust. That would be really stupid.
Okay,
never do that.
Right. So now, when we talk about full faith and fair credit amongst the states, if Alaska and South Dakota have these policies of asset protection, doesn't that balance out? Aren't they entitled to do that for the people that seek to house those liquid assets if they pass the legitimate tests of legitimacy that when they established it, it's, they didn't have a lawsuit, they didn't have any problems, they put the money in there, all the things that you said earlier. So they've made a determination that yes, we can do this, and our asset protection trust system is entitled to be respected in our respective states.
So when the Uniform Voidable Transactions Act took over from the Uniform Fraudulent Transfers Act, the prior act stopped at 0.09. The new one goes to 0.15. And one of the new sections, 0.10, is a jurisdictional section, which didn't exist in the old one. And what 0.10 says is that the law that applies to an individual is the residence of the individual at the time of the transfer. So if you've got a California person who does something bad and lives in California and he transfers it to a South Dakota trust, it's California law that applies. Now, of course, what you said is something different. You said, hey, there is no problem, and he transferred it in a timely fashion. So if you set it up in a timely fashion, you will win. There's no problem.
You've got to be completely, legitimately free of any problems under the laws of the state of California, under the act, before you do that. We're notwithstanding what the rules of that state are that you're going to for protection. You've got to make sure you're completely clean on this end, and no doubt about it.
Yep. So what you see is a clash of statutes of limitation. South Dakota's rule is 2 years, California's 4 years. So the situation you're basically looking at is, what if you're okay under the 2-year statute, but you're not under the 4-year statute? Well, California law would say you're stuck with California law. That's how the In Re Cleopatra Cameron case effectively comes up.
How do you establish an asset protection trust? What is the what would be the criteria, and is it when is it worth it for a person to do it? I mean, do you have to have a certain amount of is there a threshold amount before it becomes worth it for you to even contemplate it?
It's an interesting question because people say, you need $5 million. And what's wrong with that thinking is when you talk to this person who comes into the office, they may only have, say, $800,000. However, to that person, that $800,000 may be absolutely irreplaceable. So that $800,000 to them is more important than the $10 million to that guy over there who's worth 50. So you can say, well, the 10 million is more cost effective given the costs of an asset protection trust in Nevada or South Dakota. But the 800,000 is a whole lot more important to this guy over here. Okay. So what is the actual cost? Well, you have a setup cost. What's the setup cost? I guess some lawyers will set up a Nevada trust for 5, 6, 7, 8, 9, 10. Others will charge 11, 12, 13, 14, 15. It depends on what's included. Let me just focus on that for a minute. When we set it up, we don't just set up the trust. We also set up a single member LLC under the trust, and that's where the assets go. And the reason why the assets go in the single member LLC owned by the trust is we don't want to give the assets to the trust company, because we use one of 3 little trust companies in Nevada that charge $3,000 a year. If we put the assets in the trust, then the trust companies would charge a trustee fee. Instead, they charge the $3,000 nuisance fee. So we want to stick with the nuisance fee. Also, the clients feel more comfortable that the trust company doesn't have the assets, and they name their best friend, who could be in California, as the manager of the LLC. So we are setting up both the trust and the LLC, and getting the client qualified with the trust company is a pain in the rear end. The initials AML KYC. The anti-money laundering, know your customer stuff does take some time to get them qualified with both the trust company, and if they're smart and for liquid assets are using a financial institution outside of California, you're doing AML KYC twice. So the ongoing cost is really just the cost of the non-California trust company. So again, we use small ones that cost $3,000 a year. If you want to use the one in South Dakota that Cleopatra Cameron used, they charge a $6,000 acceptance fee and a minimum of $6,000 a year.
So once you get it set up for the 7, 8, 9, 10, 13, 14, whatever, 15,000, whatever it takes to get something like that set up, to keep those assets in a Nevada asset protection trust could, with the way the folks at your firm do it, run you about $3,000 a year just to maintain that. And what could you put in it? If you're a California, what could you put in it?
So we're basically doing them for liquid assets only. Can you use it as a limited partner in a family limited partnership? Sure. I'm just not convinced that you're really getting anything. Once you go beyond liquid assets, I'm unconvinced that you're getting additional benefit. Now, there's a confusion factor. In other words, someone gets a judgment against you, and a limited partner in a limited partnership is a Nevada Asset Protection Trust. It probably doesn't make it easier for them to get that interest. But the bulk of the benefit of a family limited partnership isn't, who the limited partner is. It's the fact that California's law on the judgment creditor's ability to get a limited partnership interest is very difficult. Right. By the way, it's not true of LLCs. We do not set up family LLCs. LLCs do not have the protection that a family limited partnership does. With family limited partnerships, there is something we call a poison pill. So the parents typically start as the 97% limited partner, and the Children's Trust has a 1% limited partnership interest, and the Children's Trust owns the 2% LLC, which is the GP. The poison pill is that if there's a judgment against the parents, the children's trust can buy the parents' limited partnership interest, but the law doesn't say what the price and terms are. So the partnership agreement says the children's trust can buy it for a 30-year interest only at Wall Street Journal Prime, interest only note, discounted by lack of marketability and lack of control, which discount could be 30 to 40%. If we used an LLC, the LLC Act, which was changed about 8 years ago, used to be the Beverly Clay LLC Act, which was our original act. We repealed it and adopted the revised Uniform Limited Liability Company Act, which says another member can buy the charged member's interest by paying the full value of the judgment. Well, I don't want that. That's a terrible result. Now, if you and I did a deal, we would form an LLC. But when we're doing family wealth planning, we only use family limited partnerships.
Okay, so there's, in addition to asset protection trusts, there, your family limited partnerships, there's a variety of different vehicles that people can use to protect their assets. What about making a trust irrevocable with in the state of California with some interest in how much control can a trustor have if they make the trust irrevocable? If you make a trust irrevocable, that protects your assets, correct? Or
if it's a completed gift. I didn't give you the introduction to asset protection planning, but part of, just a very brief part of it, is that asset protection planning is an asset by asset analysis. What's best for income producing real estate is not necessarily what's best for a principal residence. What's best for a principal residence isn't necessarily what's best for liquid assets. What's best for liquid assets isn't necessarily what's best for an ongoing business, say an S corporation. So we have what we call diagrams. And for every type of asset, there's typically 10 to a dozen different structures that people have thought about for protecting those assets. So when someone says, I want to protect my residence, I say, okay, well, let's go through the dozen ways that people have talked about protecting a principal residence, because I know every one that people have talked about. I don't like some of them, but I've got them all listed. Same thing with income producing real estate. There's a dozen. I don't like them all, but I got them all listed, and we go through them. And part of the process with a new client is going through them and finding out which ones might work best for this client, which partly is which ones they might like. And they're just not all the same. So it's, the counseling process is very important. I just don't say, hey, we're going to do a qualified personal residence trust for your principal residence. They go, thank you very much. That's not how it is. They've got to understand that there's alternatives. Each alternative has its advantages and its disadvantages.
And you have to go through all of them and explore each one and make sure.
If you don't, something goes wrong with the one you told them to use. One of the elements of the malpractice case will, why didn't you talk to them about Y and Z?
Right. Understood. Well, this has been a very illuminating discussion. It has been, I think we just scratched the surface of it basically, but it has been chock full of references to authorities. Again, it's not legal advice, but clearly you have a great amount of knowledge and total recall of these statutes. I guess you're working with them every day, all day long, every day. And it's been very informative. I'd like to have you back. I really appreciate your time with us today. Thank you very much, Bruce. And that concludes our podcast. And I thank you very much for joining us. Very
pleasure, Peter. Thank you.
You've been tuning in to Your Inheritance, Your Rights, Your Obligations, Your Responsibilities with your host, Peter Bochnewich. If you're being sued over an estate or if you feel you're not getting your share, Peter's firm can help you. You can find this show at www.betrustlaw.com and on YouTube, Facebook, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for your positive feedback, comments, questions, and for sharing the show with others.